Okay. This is a petition for certiorari prohibition with prayer for preliminary injunction and TRO against the impeachment complaint filed against the Vice President Sara Duterte. This is based on constitutional as well as legal grounds. We feel that the impeachment complaint is constitutionally deficient. It is a violation of pertinent constitutional provisions, and it is likewise jurisdictionally void, and the same should be dismissed and not entertained by the Senate of the Republic of the Philippines. That in essence is the foundation of our complaint.
Why defective, Attorney?
It is very defective because first, it did not consider the 3 priorly filed impeachment complaints. It did not likewise consider due process to the Vice President, and it did not also follow the constitutionally prescribed verification process. And because of these 3 and other grounds, the impeachment complaint should be dismissed and not entertained, rather. Okay. Verification process. The verification process requires that it should be personally known. The allegations are personally known and studied by the respective congressman who signed it. And if you notice, the congressman who went there did not even know as to the subject matter of the discussion in the House caucus. And there was only around 3 hours between 12 o'clock to 3:15 before it was included in the additional House business reference. And by that time, we feel and we have reasons to believe that some of the congressmen were not even able to peruse the complaint as well as assess the evidences attached in the impeachment complaint. And therefore, this is defective. The verification requirement has not been complied with. And more importantly, there were 3 priorly filed impeachment complaints and which were not acted upon in the Constitution. Specifically, Article 11, Section 3 thereof mandates that upon receipt of the impeachment complaint, the same should be included in the House in the order of business within 10 session days, and thereafter the Speaker should have referred it to the Committee on Justice within 3 days. And these are mandatory provisions which were not followed by the House of Representatives. And why? Because Francisco versus House of Representatives mandates that if an impeachment complaint is already referred to the Committee on Justice, the 1-year bar period shall operate. And if the 3 complaints were entertained, included in the order of business within 10 session days, and included within 3 session days in the Committee of Justice, referred to the Committee of Justice, then the 1-year bar rule would have operated, and the 4th impeachment complaint should not have been legally entertained.
Attorney, gaano po tayo confident na magkakaroon po ng TRO, especially po na may arguments na same equal branch po ang SC and Congress?
Well, it's up to the Supreme Court, but we pray that the Supreme Court will grant our prayers. Any and all questions we will entertain in Max Restaurant po. Maria Orosa po. Okay?
Asan yung mic ko?
Photo lang.
Kasama po sa aming mga petitioners po, 29 po kami lahat. 29. Meron pa sana magsali mga taga Cebu, Dumaguete and other, at saka Butuan. Hindi na namin ma-entertain. In-advise na lang namin mga taga Manila to file a petition for intervention. Kasi nga po yung coordination, pagpapirma ng verification requirements, mahirap po. So, in-advise namin sila na mag-petition for intervention na lang po. Okay? Kasama namin sila Coach Oli, sila Boss Dada, si Banat Bay, si Attorney Luna Acosta, sila Attorney James Reserva ng Butuan City, Attorney Martin Delgra, I think you know him. So, isa po itong pag-respond sa request po ng mga tao na mag-file kami ng petition for certiorari. This is a response to the clamor of the people that we should file a petition for certiorari prohibition with prayer for preliminary injunction and TRO against the impeachment complaint filed against the Vice President.
Sir, do you consider the impeachment a